What is an administration? Welcome to Frank Bruno Law. I'm Frank Bruno. After a loved one has died, there are many things that have to be done. Assets have to be gathered, bills have to be paid, assets have to be distributed, and the process of managing a person's affairs after the death is known generally as estate administration. And the legal authority to manage these affairs is granted by the surrogate's court, and that's usually in the county where the person lived. Banks and other institutions where the decedent had accounts will not speak to you simply because you're a family member. You must be appointed by surrogate's court as the legal fiduciary. It's the legal representative of the estate. And that would either be the executor if you had a will or an administrator if you didn't have a will. So if there was a will, the will would be presented to the court in a probate proceeding. And in Queens, or all of the city, it's surrogate's court. The court would then take a look at the will and go through the process of granting letters testamentary. Today's focus is on if you didn't have a will. If the decedent did not have a will, the court case is called an administration proceeding, and the representative is called an administrator. The court papers making that person the administrator are called letters of administration. They're sort of like the power of attorney for the estate, right? Upon the death of a person, no one could sign unless they have the authority of the court. If no one steps forward to manage the affairs of the decedent, the county public administrator can step in and seek to become the administrator of the estate. The public administrator, like all fiduciaries, would charge a fee to the estate for that process. Once appointed, the executor assumes the job of gathering assets, paying debts, and distributing assets. This process is almost always done with the help of a probate attorney. It's not required to, but there's some technique to it. When you distribute the assets, the executor or administrator in this case will report to the beneficiaries what the administrator has done and how he or she proposes to distribute the assets. The attorney for the administrator would prepare an accounting of the assets, and part of this accounting, the assets, the debts, and the proposed distribution. If all of the beneficiaries agree with the account, then the account would be marked settled and the assets would be distributed. So, step one upon the death of a loved one would be to look to see if there was a will, and if there's a will, then you go through the steps to probate it. If there's no will, a family member can step forward to seek permission from the court to become the administrator. That person should have the death certificate of the decedent, a paid funeral bill, and then within the court papers, explain the relation. It could be a sibling, or an adult child, or a parent of an adult child can do it. There's not a legal requirement that you be a family member. So if you were a paramour, a girlfriend, a boyfriend, a significant other for a length of time, you could also apply to be the administrator. Depends on whether or not other family members would consent to that. If you have any questions about this process, please shoot me an email, frank@frankbrunolaw. Thank you.